We have a fantastic video coming up about the TR to PR refusals or refusal for another temporary public policy. The federal court last week came out with a groundbreaking decision about updating your application before a decision is made by IRCC. So stick with us. We're going to talk about everything you need to know when you get faced with a TR to PR refusal.
Absolutely, Cedric. This is some pretty positive news, at least to blunt the sharp edges of this IRCC sword when they are destroying the lives of people who make mistakes with applications. So, Cedric, this case you're talking about, let's dive right in there now. And what can you tell us about this case, Core v. Canada?
Well, listen, Mark, you wouldn't take your medical advice from a tweet. Don't take your legal advice from a tweet either, is essentially what this federal court decision is saying. What happened in this case, and I wrote a whole blog in the comments below, in the description below, but in short, an applicant realized that they did not upload their education documents before making the when they made the application, they realized they did not upload the education documents. And this person was really smart. They made a web form and they updated their application. They asked IRCC to include the document as part of the decision. And IRCC on their Twitter and IRCC's guidance in general is that they will not accept additional documents once the application is made. And the federal court judge in Carr found that that decision was unreasonable. IRCC had to either consider the educational documents or provide an explanation as to why they did not consider these documents. And this is really new, Mark, because it's really changing the way that this public policy is being implemented. And to some degree, it's going against what IRCC wants you to do as an applicant.
Yes. Cedric, I remember in the heat of this TR to PR frenzy, international grads like this particular individual, and if we just flip back here to the decision, this was an international graduate, that particular program. Why is that important? Because they had less than a day to prepare and file their application from the moment they got the instructions. So back in 2021, when this was launched, the notification, I was right on the front lines. I was in technical briefings with IRCC. I created my TR to PR pathway course, and people had literally one day from the day they released the instruction guide to collecting their documents, completing forms, and submitting everything, including those education documents. And obviously, a couple weeks later, Cedric, maybe 1 week later, people are panicking. Who am I kidding? The same day, people were panicking. Oh my goodness, I forgot to include this form. I forgot to include this document. And in my discussions with IRCC, they said, R10 assessment doesn't apply, so the completeness check that we see with express entry doesn't apply. But there was no ability to notify them via web form because they specifically told people not to do it. So people are in limbo wondering, what the heck am I going to do? I know I'm missing a document, but there's no option to upload through the TR to PR. So this context, to have this decision at this time, Cedric, is so curious to me. Because what the decision doesn't say is how far along the process the person was. Did they have their acknowledgement of receipt? Did they try to submit previous uploads to correct this? Like, why would they wait all the way until October or whenever, that period of, I guess it was, in 2021, why did they wait so long to upload the education document? There's a lot that we don't know about this, but let's dive right into the decision here and what this really means for existing TR to PR people. And does it have any application to express entry? What are your thoughts on that?
Well, Mark, as a lawyer that worked at the federal court, that did their articles for federal court judge, so working hand in hand to provide legal advice for a judge, it's important to note that one court decision doesn't create a whole precedent that applies to every immigration stream, to every immigration application, right? But what this tells us is that for similar cases, right? So if someone who has a TR to PR right now pending, It is so important to go in and update your application. Look to see if you have all the documents, review all the forms to make sure that everything was properly prepared, or even book a consult to have us review your application if you prepared it on yourself. Now,
Yes,
if there's another temporary public policy like the postgraduate extensions or another program like Express Entry, it's going to be very neat to see how this applies going forward. So we still encourage you to properly prepare your applications, right? Work with an immigration lawyer. Let's do this properly from the very beginning. This being said, this might apply to other public policies that namely are time limited and where the officers have discretions, right? So as you mentioned, Mark, it's a 1 day program, so maybe the federal court here was more lenient, right? Took into consideration, was just open for 1 day, and they might not be as flexible for express entry and the completeness check. So it's really going to be interesting how this plays out, but I'm going to be filing this week an application for judicial review where it's almost word by word this case, and I'm going to be advocating that this is the correct approach. Applicants should be allowed to update their application before a decision is made.
I agree. And I just did a quick word search on this decision. And this is something we want to point out, right? This concept of an innocent mistake, right? And how often do we have consults with clients that have made an innocent mistake and IRCC crucifies them? So when I look at this, I say to myself, hey, the applicant contends that she made an innocent mistake attaching the wrong document in her application. So because of the frenzy, she had uploaded the wrong thing in the wrong spot, right? And she asserts that when the decision was made, the application was complete and should not have been rejected, which is what you indicated. And if you look down here in the official, where the court is agreeing, there's no obligation on an officer to request further documents. However, and this is the key, in the context of this application, where it is not disputed that an innocent mistake was made uploading the documents and the applicant took steps to correct it within the timeline and before a decision was made, then there's room for some humanity to be baked into this type of a process. So okay, so we know that it's pretty confined, but why, do you think this could, or maybe you feel it really doesn't offer a whole lot to saving people in other types of applications? Like, what is your thoughts about, taking this decision and stretching it just a little bit, like in our submissions to IRCC? Please note our client forgot to include this document, but pursuant to core, it was an innocent mistake. And, like how persuasive do you think those arguments are going to be?
Well, the innocent mistake kind of came and went with misrepresentations, right? There was some case law starting to build on misrepresentations of innocent mistakes, and clearly it's very difficult to argue an innocent mistake for misrepresentation, right? So it's we're going to see what happens. I mean, there's judges on both end of the spectrum, right? Some believe the applicants have one chance to make the application. IRCC should be, boggled down by incomplete applications, but yet you have other judges where really show a little bit more sympathy
Yeah.
to the applicants in their
Yeah.
dealings with IRCC. So where this innocent mistake takes us, it's gonna be very interesting. But Mark, let's not forget that this is IRCC's policy, right? To stop considering documents after the application has been made. And if when I'm going to be arguing this in the federal court going forward, I'm going to be even adding procedural fairness, right? There is procedural fairness that's owed to an applicant to be fair in their dealings, and the sole fact that IRCC, for example, deletes your email, right, as we've seen, doesn't consider your web form, or just decides that from now on this is the way it's going to be done, doesn't mean that it's the legal way. So we're going to see if we can stretch this out by arguing more procedural fairness. We're also going to see if other time limited programs with some discretion where this could be applicable. And really, I think there's a balance between innocent mistakes and complete applications. But this was really the TR to PR. You had one chance to get it right, and and I agree with the judge. I think it was unreasonable for IRCC not to consider the updated educational document.
Yes. When I think of application to other areas that we do a lot of express entry. So this happens a lot, you guys. Individuals who are going through their application, although it's not a 1 day turnaround, there still is an element of urgency in getting your application, your EAPR filed before the ITA expires. And once it's submitted, it's locked in. But people forget things. People realize that, oh, wait a minute, I chose the wrong knock. Why? Because they watch our video, Cedric, and then realize, oh my goodness, I didn't do that right. My application is in the queue. Now what? So what do I do? So Cedric, in this situation, you have someone who maybe has a TR to PR. And remember, they still have through 2023 to flush out all of the rest of the TR to PR backlog that they're processing. So let's say someone's watching this video and they've been just stressing and stressing because they know they've made a mistake. So let's talk about what you can do now before you get that dreaded refusal letter. And then let's transition into what options are available when the refusal has landed in your inbox. So if someone's in the situation of a TR to PR, and you know what, in all honesty, Cedric, we could apply this to any application where we have an ability to do a web form. Even TR to PR doesn't necessarily give you an opportunity to do web form, but I take the position you do it anyways to try to show good faith that you're trying to get the documents to IRCC during the course of processing. But what would your advice be to someone who's in the stage where they know they've made a mistake and now they're wondering, what do I do? Because I haven't had a decision yet, but it could be a refusal.
Yeah, so well, and it's an interesting point, Mark, because this was brand new area of law, right? And this is what the lawyer for this client did is make the web form inform IRCC, even though they did not have an established process. But what the applicant did in this case was notifying IRCC by web form. They provided the missing document, and they made a request that it be added to the file. So if you notice a mistake, this is exactly what I would do: is do the web form, provide the document, and tell them to add it to the file. And this court decision is telling us that IRCC either needs to consider it or explain why it can't be why it can't be included in the application. So, and I think it would be unreasonable for them to say, well, it was just submitted after the date. That's it would be unreasonable. The federal court here clearly says that officers have discretion, and the officer needs to show how are they exercising that discretion. What factors have they considered? They consider that it was a one-time time limited. They consider it was an innocent mistake. What are the other circumstances? But most likely the officer may not have considered your updated web form. And in that case, if you do have a refusal, you have 15 days, because it's going to be an application inside Canada, 15 days to go to federal court. So you're making an application of judicial review, and you're asking a federal court judge to overturn the decision from IRCC. And they're very strict with the 15 days. So if you're in this scenario where you have a rejected TR to PR, I strongly encourage you to book a consult and reach out to me. We
Yeah.
need to file just an application. It's 2, 3, 4 pages at the federal court to get this filed. There's more steps to it. You're going to get the Rule 9 disclosures. We're going to have to submit arguments and make an affidavit. That's later on. But the first document is very strict for the 15 days. And as you can see here, Mark on our website is going to legal help and judicial review. So you can read all about getting help for refused application, going to federal court, and what to expect. And the most important thing to note is that only lawyers can do judicial reviews, and you want to have a lawyer with experience that has done judicial reviews in the past and clearly is advocating for your interests. And Mark, you can actually switch back to our approach here. If you go on about us, our approach,
Yes.
we have now we have a direct lawyer direct lawyer to client collaboration. But if you scroll down, you're going to see for litigation, we have one-on-one litigation legal representation. So really work with you to give you advice, give you guidance, and make sure that we have a high quality advocacy in federal court to overturn the refusal. And Mark, the sad reality is that some applicants who qualified for the TR to PR, you might not never qualify for
Yeah.
another PR program.
Yeah.
Like
Yeah.
it's sad when you think about it that IRCC is essentially saying, get out of Canada, we don't want you anymore. You didn't
Yeah.
give us this education document, right? You didn't give us this one form.
Yeah. And there's nothing worse, Cedric, than for me to look a client into the eyes and say, you do not get a second chance. And with this, like, I don't know if there's ever going to be another program like the TR to PR, but even in the context of express entry with the high CRS scores and people running out of status and, like it's just really hard. Those ITAs are precious. For those who are just wondering what's this web form about, well, most people I think are probably familiar with it, but I want to point something out, Cedric, because they indicated specifically that they uploaded it via web form. And in the early days, like I alluded to, they had said that they don't accept documents via web form. So somehow, and this is another testament to sometimes you just ignore what IRCC is telling you and you do the best that you can to perfect your application. But if you scroll through here, you can see it says type of application inquiry. This is permanent residence applied online. That's what it is, the TR to PR pathway. But if you look at the list, there's no TR to PR anywhere. So if you go here, express entry is the only option. If you try to do permanent residence applied by mail and you pull it up, you can see there's no TR to PR option here. So when people are submitting and uploading documents, this is like, there are things that you can do to try to fill in as much information as possible to direct the documents to the right location. But I'm super, super curious as to what, in the context of uploading the documents that CORE did to, that was sufficient to allow IRCC to accept it. So, ultimately, when we look at these things, the moral of the story is, if you get the proper help, the proper legal help to assist you, there is ways to navigate through this stuff, both on the front end before a decision results in refusal and on the back end. And we do a lot of that stuff. So Cedric, any parting words? We've, obviously, if people have further questions, all they need to do is just go to our firm website. Here's Cedric's information. It's super easy to book a consult with him. But to remember that the consult is just step one. It's like, this is full litigation, one-to-one legal representation. And that is what Cedric does. And we're so happy to have him within the firm. So any parting words, Cedric, for viewers that are watching this video?
Yeah, so we focused a lot on updating documents and whatnot. So, I would strongly recommend that to take the time this weekend, in the evening to review your application. It's not fun, right? Put on a show, put on some Netflix, but seriously, review your application, take the time you need because it's really a one-shot application. Submit those web forms, update your application, and make sure it's properly prepared. And don't forget that you can go to federal court for other types of refusals, such as misrepresentations, right? Or even you don't meet the eligibility, or if the visa officer also made a mistake, right? You did provide the documents, they're telling you, no, you didn't provide it. So there's
Yeah.
more avenues, judicial reviews to keep in mind. And we're here to help, Mark. We're here to get this right. But as you mentioned, you have to get it right the first time, right?
Yeah, absolutely. And some people may not even know, Cedric, where the problems are within their applications. And we've done a lot of these direct lawyer to client collaborations where we work together to go back in and review what was submitted. That's one of the benefits of the TR to PR. You've got access to all the forms and documents that you've submitted. And so it's very easy. Everything all starts with just speaking to us and navigating what the best options are, and just going to the firm site, clicking on the link to book a consult. And it's super easy. You click on for Cedric here. You can see right at the time of recording, and we're just about getting ready for Christmas, but Cedric is fully available for support. So each of these days. So he's open for business. And if you find yourself in this situation, I strongly encourage you to connect with the firm. And there's links in the description below to the case that we're talking about here, to Cedric's blog posts, and to booking a consult with Cedric. All right. Thanks so much, Cedric.
My pleasure, Mark. Thanks for having me.
You bet. Take care.